8:05, Jeff Katz, News Radio 1140 WRVA. Well, questions arise about who's responsible when a crime is committed, right? Most of us understand it is the criminal makes a choice to commit the crime. Others are looking for a payday from somebody, and gun manufacturers, of course, have deep pockets. Edwin Walker is joining us. He's an attorney with the U.S. Law Shield. Edwin, thanks for being here.
Well, thank you for having me.
Let's talk about this case at the Connecticut Supreme Court. What's going on here?
Yeah, this is a case that is arising out of the Sandy Hook shooting. And what is, of course, some families of some of the victims of the Sandy Hook shooting have decided to sue Remington, who is the manufacturer of the Bushmaster rifle that was used by Adam Lanza, the shooter, to commit this. And, of course, their case so far has been dismissed because there's a federal law that says that a gun manufacturer is not liable for injuries that are committed whenever a criminal act is used with their particular instrument. Of course, they're still liable if they make a default, a defective instrument, one that blows up and the shooter acts of negligence, things like that. But it pretty much just sort of codifies what has existed in the common law that says there's, whenever there's a criminal intervening act, that eliminates proximate cause liability with regard to certain products.
Well,
and so this just federalized it, and it's been successful in many cases, most notably the Aurora, Colorado theater shooting.
Right.
Those cases were completely dismissed because of this law. I guess what's novel about this is, number one, it's Connecticut, who is known as a very anti-gun state.
Right.
So they probably got a sympathetic audience. And number two, they're putting forth this very, very unique, but yet, in my opinion, misguided theory that somehow the gun manufacturer is guilty for negligent entrustment, which is one of the common law exceptions to this federal law.
Well, but isn't this really, in many ways, ginned up by all of the anti-gun people? And I listen to people who are news reporters who don't know anything about firearms, and they go out of their way to try and describe a gun, and you go, that's not right. Or they use a phrase like semi-automatic, and you go, do you even know what that means, as opposed to automatic? And then they use it with the phrase assault weapon. It's just this melange of ignorance that's out there. Would we be able to sue a car manufacturer because somebody killed a child with a car? Would that fly?
Well, no, I don't think it would. However, you have to look at this, that yes, they in sort of the latter half of the 20th century, tort law became so out of control that it has been used as a quasi-regulatory element. It has been used against the car industry. I don't know if you remember Ralph Nader's, assault on General Motors and Corvair, unsafe at any speed. It, of course, was used very effectively, quote unquote, against the tobacco industry. It's been used against the pharmaceutical industry. And so these products that are legal products, whenever they are misused or they're used that in a way that the folks who made them didn't intend,
right.
There are going to be people out there who are injured that are looking for a payday, but also they're also using the court system to regulate these items in such a manner. Well, in the case of gun manufacturers, since obviously their exposure is so prevalent, because of course anytime a gun is used, there's been a life that's lost. It's tragic. Everybody's sad about it. Of course, pro-gun and anti-gun advocates are always arguing in the legislature about what should be done. And they have tried to use this lawsuit process now, and you're right, it does go a lot to the nomenclature. Several of the articles that have been written about this, incorrectly characterize this rifle, the Bushmaster, as a military-style rifle.
Right.
Well, I guess if you're just talking about aesthetics, does it look like a rifle that a soldier would use? Yeah, but that doesn't have anything to do with its functionality,
right,
or its lethality.
Absolutely. Edwin Walker, thank you for being here. Edwin Walker is an attorney with the U.S. Law Shield. They help protect the rights of gun owners on a regular basis. And he's right. It's all about the aesthetics. Oh, my God, it's black in color and it has flashing. Yeah, it doesn't make it an assault weapon.
Joining us right now, though, we want to talk to somebody because there's an interesting lawsuit. Speaking about school shootings, and yesterday, let's again acknowledge we avoided what could have been an absolute horrific catastrophe at an elementary school. But whenever you think about school shootings, I think most of our brains go to Newtown, Connecticut.
Yeah, Sandy Hook.
I think a lot of people think of that. Well, joining us right now is Edwin Walker, and Edwin is a program attorney at U.S. Law Shield because, and Edwin, we have you on here, maybe you can explain this in layman's terms. There is a lawsuit being brought by victims of the Newtown shooting towards the manufacturer of the gun. I thought that you couldn't do that, but they're making a bit of a different argument this time, aren't they?
Yes, that's correct. According to a 2005 federal law, a gun manufacturer can't be held liable for any kind of product under any kind of product liability theory whenever their gun is used in a criminal act. It's a principle that existed in common law. There's what we call a superseding intervening cause. So it just simply codified what was already in the common law. However, whenever you're relying on common law, courts can kind of do what they want, and obviously they're, even though they're supposed to be independent, they are susceptible to political influences. Sure. And so the Congress said, look, we're going to make sure that this principle is ingrained into our statute so that any case that's brought against a gun manufacturer because of an illegal act that's done with their product can't survive. And that's exactly what happened in the Sandy Hook case, is that they, of course, the victims' families sued Remington, who made the Bushmaster. Their lawsuit was poured out, and what happened yesterday was they got to argue in front of the Connecticut Supreme Court that their lawsuit should be reinstated and allowed to proceed because they were trying to shoehorn these facts under one of the very, very narrow exceptions to that law. For example, gun manufacturers can still be held liable for their defective products. So if they build a gun that it explodes whenever you shoot it, or it was poorly designed so that it injures the person through an act of negligence, those lawsuits could proceed. And one of the acts of negligence that they are claiming would allow this case to proceed is that they are claiming that the manufacturer had negligently entrusted their firearm to the public, which is very unusual because they have to show that they negligently entrusted it specifically to Adam Lanza, the shooter, which the facts don't support that. They obviously sold and marketed it to his mother, who was, by all accounts, a lawful gun owner, and in fact suffered, as the first victim of this guy.
Good point.
So their theory, while novel, I think, even though it's novel, even though you may accept, well, that's certainly a possibility, I think it fails completely on the facts because clearly there was no way that gun could have been marketed to Adam Lanza himself.
We're talking to Edwin Walker. He is a program attorney at U.S. Law Shield, and we're talking about the case that families of the victims of Newtown have brought against a gun manufacturer, Remington, for the Bushmaster gun that Adam Lanza used to kill 20 first graders and 6 educators back in 2012. And Edwin, my question to you, well, I'd like to see something change. I don't know what that would be. I just think that what happened in Sandy Hook is absolutely horrific, but I don't know what law should change or if it could change. This one seems flimsy at best. But my question is, how will the outcome of this case impact other gun manufacturers?
Well, the outcome of this case is going to be critical. And the thing about it is, if the Connecticut Supreme Court, in which courts have upheld this in very high-profile cases before. In fact, in Colorado, pretty much the exact same lawsuit was brought against the gun manufacturers arising out of the Aurora theater shooting, and those cases were all dismissed and never revived. Here in Connecticut, in Connecticut, they may say, the law is the law. We're not going to expand on it. However, Connecticut is a very, anti-gun state. And so the members of the Connecticut Supreme Court may say, well, we're going to go ahead and we're going to reinstate the case under this exception. However, the thing about it, since it is a question of federal law, it is definitely the sort of case that would then be appealed to the U.S. Supreme Court.
Yeah, it's a tall order, to say the least.
That is correct. Now, obviously, in the last half of the 20th century, sort of regulating industries through litigation has become extremely popular. We see it in the auto industry, certainly with the cigarette industry, with the drug industry, that where there's a perceived lack of government regulation, there have been plaintiffs, and particularly plaintiffs' lawyers, who have been willing to sue manufacturers of products, even when those products are used in a completely unauthorized and many times illegal way. They've been trying to regulate their activities through litigation, and obviously the U.S. Congress saw this coming down the road with regard to guns, and they realized that guns are not only a constitutional right but also a large portion of American industry.
Yeah. Exactly. Interesting. Okay.
Thank you so much. That's Edwin Walker, program attorney at U.S. Law Shield.